Hi, Sherry. How are you doing?
I'm good. I'm sorry, I'm multi.
Okay, I think we are going to go ahead and get started. Today's presentation is going to be on prosecution. Our presenter is Sherry Townsend, who is the head of the criminal division with the Dakota County Attorney's Office. My name is Jenna. Both of us are on the Dakota County Sexual Assault Response Team who has put this training together. It is the fifth in a series of 6 in honor of Sexual Assault Awareness Month, which is April. So with that, Sherry, I will turn it over to you.
Thank you very much. Hopefully my sound is okay. I sometimes get a few issues with sound. So Jenna, if there's anything where people can't hear or anything like that, please let me know, or if things echo. I'm honored to be talking about this subject matter today. I've been very fortunate in my career to be a prosecutor for over 23 years now, I think it is. And for many of those years, I've been honored to work on sexual assault cases for either adult or child victims. So it's a real privilege to talk about this and to be a part of the sexual assault response team in Dakota County, because I think coordinated efforts by justice partners on these cases is important, and I'm so glad that we're doing that. I just have a little bit of background about the county attorney's office here. As some of you know or may know, the mission for the Dakota County Attorney's Office is the promotion of justice, public safety, and effective government by prosecuting crime, protecting those in need, and representing Dakota County. Obviously, as head of the criminal division, our focus here is on justice, public safety, and prosecution of crimes and public protection. We do not represent the county in the criminal division. We prosecute crimes. Just a little bit of a layout of the county attorney's office, just for those of you who are not aware. I'm not sure where people are for their experience levels or participation in this. So I would just note that the county attorney at this point is Kathy Keena. She is the acting county attorney. Many of you knew that Jim Backstrom was the county attorney for many, many years, and he recently retired. So Kathy Keena is the acting county attorney, and also a dual role as chief deputy as well. So she's pretty busy. There is a more of a civil end of things, which is the first assistant and who oversees the civil division and child support enforcement, civil litigation, and counsel for Dakota County. There's a branch with community relations that particularly has victim witness involved as well, and that's going to be a very important part of the discussion of the role of the county attorney's office in these prosecutions or investigations. And then there's over here, the chief deputy oversees the criminal division, drug prosecution, and juvenile protective services, and the appellate division. And as you can see, we cover any number, sorry, I popped forward there, any number of areas in the criminal division under adult prosecution, and that certainly includes sexual assault and child abuse cases. Our system of justice is governed by the courts primarily, and as many of you know, we are, focused in the Minnesota Judicial Branch. So our cases take place in Minnesota State Court, in District Court. So here in the Judicial Center in Hastings, we have the courthouse, and that is where we litigate our cases. We also have appellate courts that the county attorney's office operates within and under when cases go up to the Court of Appeals or to the Supreme Court. We also have a function in litigating cases that get up to the Court of Appeals and the Supreme Court. If something is challenged for any kind of a conviction, if there's a challenge that we want to raise in limited circumstances, appeals can go up to both the Court of Appeals and the Supreme Court. There's also federal courts that are applicable, but not to us. Federal courts hear federal cases. We are operating in state court on state court cases, but I just wanted to put that in there. The sources of our laws, there you see a list of any number of sources where the parameters for what we charge and where we operate are listed here. Our primary parameters here in state court are the laws come from the Minnesota legislature, and certainly some of the appellate court decisions that guide us in how we litigate our cases. One thing I'll just say real quick about the Minnesota legislature, I'm sure some of you have seen that there's been quite a bit of media attention lately to revision of laws as they relate to sexual assault cases. That is happening literally, likely as we speak, or now. Contemporaneously to this week, this month. I know that there's been a lot of discussion about there was a task force that was involved in revamping some legislation, and I know that that has been making its way through our Minnesota legislature with revisions and discussions about various provisions. A lot of people have done a lot of work, and we hope that we see some possible changes in legislation coming up here pretty soon. It will all depend on if it passes, but that's kind of a hot topic right now. Prosecutors in the system are known as ministers of justice. We are guided by our ethical responsibilities and our duty to seek a fair and just result in an unbiased manner. And in order to issue charges in a case, we need to conclude that there's a reasonable likelihood of success at trial. That's part of our ethical obligation. And that can be something that can be, it's important for us obviously to be guided by that, but it's also something that can be a bit of a challenge as we discuss whether cases can go forward to trial, whether cases can be charged. We certainly have to keep our ethical obligations in mind, and we have to be able to have discussions with people, possibly victims in cases such as sexual assault cases, relating to those obligations as it relates to their case and what may have happened to them. So I put that in there because it is something that frames our work and can be something that we have to discuss with people when we're deciding whether to issue charges or not. We work with numerous justice partners through the county attorney's office, particularly as it relates to cases involving allegations of sexual assault. I've listed just a few down there, but these are the big justice partners that we end up working with the most. Most frequently, we are working with law enforcement, particularly as it relates to cases coming in for us for consideration of charging and what investigation we might need to assist in the ability to make a charging decision in any case, but for the particularities of this presentation for sexual assault cases. Obviously, members of the public are in a sense our justice partners. We work with witnesses and victims and jurors, people who have become a part of our criminal justice system by virtue of sadly being victimized, sadly witnessing some sort of criminal activity, or being called in for jury duty and having the duty to sit and listen to evidence and make a decision based on the evidence that is presented to them in court. Judges, of course, I guess not necessarily justice partners, but people that we certainly work with through this system, and judges are an integral part of any process with any case that goes to trial. Really significantly, victim advocates. We work with 360 communities, of course, and we have victim advocates in our own office as well, who work with people who are victims of crime to help them get through the legal process in the criminal justice system, because it is not always a friendly or something that they are comfortable with, and it's very important that we have people who can help shepherd them through this. One of the things that is particularly challenging, I think, for sexual assault victims is the nature of what has happened to them, and the crime that was committed against them is very traumatic and very difficult to talk about often. And then you imagine going through a criminal justice system where you need to tell that story and what happened to you in front of multiple strangers and in front of the perpetrator. And so the victim advocates that we have worked with do a phenomenal job of helping victims get through the process by helping answer their questions and explain the system to them. We work with community corrections. Certainly if people are convicted and if they are placed on probation, community corrections often will be the ones supervising them. And when there are allegations that perhaps someone is not meeting their provisions of probation, what they were supposed to do, we often have communications with supervising agents to discuss any concerns that we have about the case and what has happened. And court administration as well. Court administration obviously is juggling quite a bit with scheduling cases and the numerous cases we have backlogged because of the pandemic. So we have many, many communications related to cases with court administration as well to ensure that we can make sure we get these cases through the system and prioritized given the pandemic and the backlog of all kinds of cases. So the criminal division of the county attorney's office is the division that works particularly on the prosecution, the review and potential prosecution of sexual assault allegations. Now, I do have a slide in here later on about the juvenile division. I will say the juvenile division also considers cases for criminal sexual conduct and also reviews them. They have a little bit more of a different focus, and I'll touch base on that when I get towards the end. But for the most part, the parameters that I talk about here are applicable to both the criminal division and the juvenile division. It's just the juvenile division has a little bit of a different focus with their work with juvenile perpetrators. So in our criminal division, as people who are on the call may know, when there is an allegation of sexual assault, someone indicates that they have been victimized or sexually assaulted, the first step is hopefully to get to law enforcement or for medical assistance if they need it, depending on what happened. But typically, an allegation of a violation of our criminal sexual conduct laws is reported to law enforcement, and law enforcement commences an investigation. Sometimes that report comes directly from the victim to law enforcement. Sometimes the victim has gone in for medical assistance and law enforcement gets involved if the victim gives permission for that to happen. But typically what we see in the criminal division is that law enforcement commences an investigation. And sometimes that is done without input from the county attorney's office, but oftentimes I will get a call, or people in our office who prosecute these types of cases will get calls relating to active investigations to ask questions and get any kind of guidance that could be that could assist in successful prosecution of these cases or successful investigation. So it's not infrequent for us to get calls from law enforcement ahead of when they're submitting the case, because there can be legal issues that come up. There can be issues with search warrants, whether a warrant could be done for the suspect to search the suspect for any forensic evidence. Searches and seizures of property or suspect phones. Those are areas that oftentimes law enforcement will consult with us, and oftentimes they won't. I mean, law enforcement will frequently conduct their investigation without input from us because there just isn't time and they're moving quickly, and sometimes they will get in touch with us as well. Sexual assault cases warrant some special consideration. As someone who's worked in this area for multiple years, I am aware that victims can be very traumatized from sexual assault for obvious reasons. And what you will often see is victims who have given multiple statements relating to their sexual assault. That can be to law enforcement. That can be in the course of a medical evaluation. It can also be in the course of some sort of a forensic interview if it's done with a child who is alleging sexual assault. These cases warrant special consideration for prosecutors because they are unique in the sense that there is particular trauma that comes along with sexual assaults for victims. And it's very important that as prosecutors, we are aware that often by the time we see these cases and are considering these cases for charging, sexual assault victims have undergone any number of interviews by people, or any number of times where they have been questioned by law enforcement about their case. So it's very important that as prosecutors, we are aware of those circumstances and that we consider those circumstances when we look at the case and say, there might be some inconsistencies, or there might be some details or something that is added that wasn't brought out in the first interview. The attorneys who prosecute sexual assault cases in our office are very aware that that can be the case, and are aware that victims often will report initial details that are acute and fresh in their minds, but that does not mean that they are giving all the details, and that it is not uncommon for additional details to come forth after the passage of time. And that's something that's really important as we as prosecutors consider whether a case could be charged or not, because of the unique nature of this trauma and because of the unique nature of the cases. We have that information in mind as we look at cases that come in where a victim has had to recount what happened to her or him on numerous separate occasions. Just as it relates to forensic interviews, I wanted to chat a little bit about that term. I also specialize in child abuse, so I've prosecuted any number of allegations of sexual assault against children. And there is a particular training involved with forensic interviews or interviews of children. As the people on this call may realize, and again, I don't know where everybody's experience or backgrounds are, but when interviewing a child, it's very important that the way the interview is conducted in a way to solicit information as opposed to giving information for affirmation from the child. So it's really people who do interviews of children who are alleging sexual assault usually do have some particularized training and experience in that assists in making sure that the information we are getting is not suggested information, but is information that is genuinely reflective of what has happened to the child. So that is not always as applicable with adult sexual assault victims, but it is certainly applicable with child sexual assault victims. And I always strongly encourage and hope that people who are interviewing children who are alleging sexual assault have that experience and training, because that assists in our abilities to present that information in court. The medical evaluation information as well on this slide is very important. When someone comes in for a medical evaluation after they have alleged sexual assault, oftentimes they will see a sexual assault nurse examiner who is someone who is specially trained in both the collection of evidence and the treatment of victims who have alleged sexual assault. And one of the reasons a medical evaluation is helpful in a criminal prosecution is that medical evaluation, when it's done for the purposes of medical diagnosis and treatment, which it always is, the information that the victim provides can often come into evidence without the victim necessarily testifying about it, because it's done for the purposes of medical evaluation and treatment. And that is something that we can have come in as an exception to the hearsay rule. And that's been a tremendously helpful tool for successful prosecution. First and foremost, of course, is the importance of a sexual assault victim getting medical treatment so she is safe and treated and healthy. When a case comes into us for the purposes of review, I've just listed just 1 through 5 are criminal sexual conduct statutes, and I'll talk very generally about them. Frankly, going through all the provisions of each of these statutes would be a training in and of itself. But typically, the charges that we are looking at are criminal sexual conduct in the 1st, 2nd, 3rd, 4th, or 5th degree. And what places a particular allegation in one of those categories or in any of those categories really depends on what happened to that sexual assault victim, what the circumstances were at the time of the sexual assault, what the age of the victim was at the time of the sexual assault, and whether there was force or injury. And that's just to name a few. And I can tell you that as I thought about this training, I thought about whether I would include all the different provisions of first, second, third, fourth, and fifth degree criminal sexual conduct. And then I thought about the fact that many of these provisions and these statutes are going to have, with any luck, some modifications and changes based on some work that the legislature has done. So anything I would say right now might be a little different tomorrow or next week. So, but I can tell you that as we're considering what an appropriate charge is for these cases, we look for criminal sexual conduct in the first degree. I can tell you just generally some good examples of what constitutes that is penetration. Most of the time, first degree cases are penetration. Children under the age of 13 or under. It can also be with adults where there is force or coercion. It can be with a child where it is multiple acts and there is a significant relationship of some kind between the perpetrator and the child. Those are just some examples of what could be first degree criminal sexual conduct. Second degree criminal sexual conduct is contact, not penetration. So it is, the allegation is that there was sexual contact, meaning touching of the breasts, the intimate parts, the genitals, but not penetration. And that is criminal sexual conduct in the second degree. And again, any number of subdivisions to second degree, age-based, multiple acts, certainly whether the person had any injury or any force was exerted can be used to charge second degree as well. Again, that's just a surface of the provisions of second degree criminal sexual conduct. There are any number of subdivisions where contact under second degree criminal sexual conduct can be charged. Third degree, the most common that we see in third degree, which is again another penetration count. So you have first degree as penetration. There's also a provision for genital to genital contact in first degree, and that relates to younger victims, underage child victims. But first degree is primarily penetration, and third degree is penetration. And third degree, what we typically see when we are considering charges are adult victims who have been sexually assaulted and someone has used force or coercion against them. Can be an adult victim who has some sort of a relationship with the perpetrator that puts them in some sort of position of authority isn't quite the right word, but position where they have some sort of control. For example, a member of the clergy or your psychotherapist, massage therapist, any number of people who have certain positions can be prosecuted for third degree criminal sexual conduct if they have if they engage in sexual penetration with an adult victim. There are also charges that can be brought under third degree and also first degree relating to a person's mental capacity, their level of consciousness, their ability to consent. That is a very big topic right now with the legislature. There was recently a Supreme Court decision that came down in the state called State versus Khalil. And that was an issue where the case had been prosecuted under mentally incapacitated, that the victim was mentally incapacitated, but the language of the statute specifically said that it had to be involuntarily, that she had, in the Khalil case, I believe the victim had consumed alcohol and was very intoxicated. And I think with any number of us, as we look at these cases, we think there's no way she could have consented, but it got prosecuted under the definition or convicted under the definition of mentally incapacitated. And that definition specifically outlined that the victim had to have involuntarily consumed alcohol. And so the way the statute was drafted, the Supreme Court said that statute is drafted in a way that it has to be consumed involuntarily, the alcohol did. And so they reversed his conviction and certainly very much encouraged the legislature to fix that provision in the law. So anyway, that is something I know that is in that working group's proposed legislation to fix the definition of mentally incapacitated. So it didn't require that the victim had to somehow involuntarily consume alcohol. Fourth degree is also a contact count. And again, lots of provisions under fourth degree where there could be charges. It can be force or coercion for contact, again, with the intimate parts, including the breasts and the genital area. And fifth degree is non-consensual sexual contact. So, and that right now at this point is a gross misdemeanor at the first time offense of just basically going up to someone and touching their intimate parts without consent. And so I alluded to a lot of these as I was going through those. And again, those are not nearly all the provisions of criminal sexual conduct, sections 1 through 5, but those are just some examples. Some of the main things so that we consider when we determine what would be an appropriate charge for a case when a case comes in for investigation or after investigation is completed for consideration of charges, the age of the victim, whether the victim has any injuries, whether there was force or coercion that was applicable, whether it's contact or penetration, tells us which provision of the law we need to look at. Both can also is also very frequent. The victim's consciousness, their mental capacity, or his or her ability to consent, we certainly look at those circumstances. And the relationship between the perpetrator and the victim. These are, obviously there are more areas that we look at, but these are the main areas that we tend to take a look at when we are trying to figure out when an allegation comes into us after an investigation. Where do we look for statutory guidance as to what we should charge in the case? And the relationship between the perpetrator and the victim, as I think I alluded to, sometimes it can be that there's a significant relationship, like a familial relationship. It's a father, it's someone who lives in the house, it's a mother, it's a brother or a sister. Or it can be that relationship I mentioned earlier, a psychotherapist, a member of the clergy, someone who is in some sort of a position where they are providing some sort of an assistance to the person, making that person particularly vulnerable to any kind of sexual contact or penetration. So when the investigation is submitted to us, we look at everything. We look at everything we can, and we certainly encourage law enforcement to interview everybody who could have information about the case. So we get police reports, we'll get interviews of witnesses, we'll get audio, video, photographs, laboratory reports, digital evidence. Phones have become a very, very big part of this. I can tell you that there was a conversation that I had with law enforcement a while back, and like any number of law enforcement agencies, they were struggling with cases getting charged where the victim had consumed a significant amount of alcohol or was under the influence and clearly very, very impaired. And what kinds of things can we do to get these cases reviewed and charged if they're chargeable? And the conversation I had with law enforcement is in particular as it relates to circumstances where victims have consumed a large amount of alcohol or are under the influence, and it seems that they are not able to consent because of their level of impairment. Any information we can get about the surrounding circumstances is incredibly helpful to us. Video surveillance, witnesses who are able to testify to the victim's level of impairment, anything that can help us with that, because the sad part is when victims have consumed such a large amount of alcohol, it often impairs abilities to remember. And so any information we can get to supplement what information he or she recalls in the course of this is incredibly helpful. And one of the more gratifying moments I had after that conversation was a case that came in about a month later, and it was the investigator called and said, this is what we did. We found everybody. We talked about the conversation that you and I had about, video surveillance, any witnesses who were there, any other people who were around, any people who could testify as to the nature of their relationship or interaction before this point. And we got it all, and they did, and they got it all, and it made it a provable case because the victim certainly had some issues with memory as a result of alcohol consumption. And so anything we could get to corroborate or just figure out what exactly happened was incredibly helpful to that case. And we did successfully prosecute that case. So the case, after we get that information from law enforcement, oftentimes we'll review it and we'll look and think that we are able to charge it right away. The prosecutor will be assigned and will review the case for charges, and the legal standard for charges, as many of you know, is probable cause. Is there probable cause? Is there a reasonable basis to believe that the person charged with the case or suspected of the case committed the crime? And if we have that, we often issue that a charge. I can tell you we have to couple that with our good faith belief that I mentioned earlier, our ethical obligation that the case can be successfully prosecuted. So we can have probable cause in a case, but we may be aware of issues with the case that may make it a challenge to prosecute. And we have to balance that, and we have to couple both probable cause with that ethical obligation. It's because of all the unique issues that go along with successful prosecution with sexual assault cases that we have specialty prosecutors to handle sexual assault cases. Not everybody in our office handles sexual assault cases. Right now, we have 8 prosecutors who are trained to handle sexual assault cases, and that is because of just all of the things that I've already cited to you. These are unique cases. They come along with unique issues. They have victims who are extraordinarily traumatized by what has happened to them and who will need people who are able to listen, empathize, support, and help them through the process if the case goes forward. And so our prosecutors are specially trained to do that. And we have a sexual assault team that meets fairly regularly to talk about particular issues that present with these cases and how to address those. We also have in our office what I named a child abuse resources folder that has motions, memos, any number of things that can help be resources for child abuse and sexual assault prosecutors. So there is an existing bank of information and law and resources to help. We have folders on experts. We have memos and motions. We have any number of things that people can look at, so nobody's reinventing the wheel and we're being consistent in our voice on these cases. One of the biggest things when it relates to prosecution for sexual assault cases is victim contact, connection, and preparation. It's really important from the outset that victims have a contact person in our office, and that is oftentimes a victim advocate at the start. And oftentimes it is the prosecutor assigned as well. I encourage and support pre-charging meetings with victims as often as time permits, because it's very important for us to first connect and listen to that victim, and second, to talk to the victim about how they are feeling about the process. Because by the time the case gets to us for review of prosecution, it may have been a little bit since their report, because the investigation had to accomplish certain things, had to get certain evidence. Maybe there was forensic evidence from a digital evidence from a phone. Maybe there was forensic evidence from the BCA that we were looking for. So it's really important for us to touch base with that victim and see how he or she is doing, and see how he or she will feel about the case going forward. As I mentioned, there are issues with reporting. I don't want to, I guess issues isn't quite the right way to put it. I want to make sure it's clear that it's not that it's wrong. It's just that it is that oftentimes victims will report bits and pieces in multiple different sessions because of the trauma they've experienced. So it's important for us to be aware of that and consider that. Forensic evidence is often present in sexual assault cases. It often isn't, but we want to make sure that people we have doing these cases are experienced and able to handle issues with presenting forensic evidence, DNA, injury, Y chromosome DNA, which is a very common thing, which is a male DNA profile that it doesn't necessarily match the perpetrator, but all of his paternal, and I'm just saying his because of Y chromosome, all of his paternal relatives cannot be excluded. He or his paternal relatives cannot be excluded. So it's a less precise DNA evidence, but it's DNA evidence nonetheless and has a lot of value. So we want people who are experienced with using that evidence, understanding that evidence, and presenting that evidence. Sexual assault cases often come with lots of pretrial litigation as well, so they can be complex in that way. I cited to Parody in my slide there, and Parody is the name of a case that we use when someone is basically trying to get a motion to dig into some of the victim's private records. Oftentimes, defense attorneys will say, well, she's in therapy, so we want to see the therapy records. And that's what's called a parody motion in state court here. They file a motion saying, we want to look at the therapy records. Of course, my reaction is, of course she's in therapy. You sexually assaulted her, your client did. But I will say that we routinely fight those motions because we also are making sure that we are protecting the privacy of the victim as much as possible. And making sure that the victim doesn't feel like part of going through this process is having someone dig through her personal records or his personal records and look at what he or she said to a therapist. Sometimes they want to get school records if the victim is a child, or other private records that might be protected. And the law says that they don't get records of the victim therapy or school records or anything like that without making a showing first that somehow those records are relevant and material to their defense. And I will say most of the times we don't see them doing that. We see attorneys filing these requests for these records just based on the fact that somehow they've learned of their existence. And our obligation is to push back on that because the law says that you can't engage in a fishing expedition for these records. You really need to make a showing that these records are somehow material and relevant to your defense. And most of the time, the defense attorney will say, well, how can I know if they're material and relevant to my defense? Because I don't know what's in them. And our argument is there's a firewall up. There is a firewall up between this victim's private records and what you want. And in order to get over that firewall, you are going to have to meet that threshold. That's because those records have special protections in place. And that's one of the ways that I've encouraged my team here in the county attorney's office to build trust with victims in these cases, that they know that we are going to fight to those motions. Sometimes victims say, I'm okay with that person knowing what I've said to my therapist, because what I said to my therapist is about what that perpetrator did to me. But most of the time, victims don't necessarily want people to be digging through their private records, and we routinely try to fight those motions. What we see very frequently, unfortunately, is that the motions, sometimes the judges will say, well, I won't just turn them over, but I'll do an in-camera review, meaning you submit the documents to me in a sealed envelope. I'll review all of it, and then I'll only release anything that I see is relevant and material to the request. And we still fight. A lot of people will say, well, why don't we just let them do an in-camera review? We still fight the in-camera review. We don't want those records just being dug into, even by the court, if we can avoid it because of the privacy issues that go along with that for victims of sexual assault. But we do frequently see the judges say, well, I will do an in-camera review. I will just look at them and only release what's relevant. That's the next step if we lose the battle, that you don't get to look at them because you haven't met your legal threshold. We also are dealing with jury trials with questionnaires. You know, as people know, oftentimes, and sadly, prospective jurors have also had personal experience with sexual assault, either with a family member or themselves. So we are often talking to prospective jurors in these cases about trauma that they may have experienced or that someone close to them has experienced. So that's another thing that's unique to sexual assault cases, either child or adult victims, is that in the process, if the case is charged, of selecting a jury, in the case, we want to make sure that we are talking to people and finding out if they've had experiences themselves that are traumatic. And I think a lot of people think that, you know, the goal is that you want to try and get people with that particular empathy on your jury. And I certainly, if someone is comfortable with hearing the evidence, yes. Would I like someone who understands the issues that I've already chatted about that come along with these cases? Sure. But I've had any number of circumstances where just coming into the courtroom and hearing what the case is about has prompted a prospective juror to literally just burst into tears, because the idea of sitting and listening to evidence about a sexual assault brings back their own trauma, and we just let those folks go. I mean, I never really fight to keep those people on the jury. It is not my interest to re-traumatize anybody and have them sit through a case where they have to listen to that. So my typical approach to that is to let those folks go. If the judge doesn't usually need to have us go back and forth about it, because I will just step up and say, we're not gonna try and keep that person on the jury. There are also very unique sentencing issues that go along with sexual assault cases. As people may know, several of these cases fall into presumptive probationary offenses, and several of these cases fall into presumptive prison cases. So your criminal sexual conduct in the first degree is 144 months. It's a mandatory minimum. Certain second degree offenses are 90 months, say if it's multiple acts with a family member or child victim. But some second degree provisions are presumptive probation. If it's a single act of sexual contact with a child victim, it can be a presumptive probationary offense. And in fact, for a single act of penetration, it can be 144 with someone who is of a certain age, but then a single act where you can't prove penetration, but you can prove contact, drops it down to a presumptive probationary sentence of 36 months. So there's certainly, from my perspective, a gap in the sentencing provisions between those two offenses, in addition to any number of other offenses. And we also are frequently dealing with what we call aggravating factors in these cases, where someone's treatment of a victim may be particularly cruel or particularly egregious. We recently prosecuted a child sexual assault case here in Dakota County where the victim was treated with such cruelty that it ended up warranting a 360-month sentence for criminal sexual conduct in the first degree. And the attorneys who work on these cases know these cases well enough to know what types of conduct is going to fall into an area where we are going to seek an aggravated sentence. We're going to seek more than what the sentencing guidelines permits us to get on these cases when they are particularly egregious. So the review of the evidence when the case comes in, it's very important for us to have as much of the investigation, if not all, as soon as possible. I know that we've had a presentation from a sexual assault nurse examiner already in this particular series, and as far as I'm concerned, their experience, training, and what they bring to a criminal sexual conduct case cannot be overstated. The sexual assault nurse examiners that I've had the privilege of working with over the course of my career are trained, very competent, very empathetic human beings who do a tremendous job with people who are experiencing tremendous trauma. And they do a very thorough and detailed report as they are taking information from the victim as to what has occurred and documenting their forensic examination of him or her. And I highly encourage, in cases of recent sexual assault that are coming in, say a person is in custody and we have a short time frame to charge the case, that we get that sexual assault nurse examination report, because that report usually contains almost all of the information that I'm looking for in that slide that I mentioned earlier: the age of the victim, any injury, any impairment, any relationship to the perpetrator, documentation of those injuries. Photographs are often taken. They often will take samples for toxicology and for testing. They take blood samples for DNA on numerous occasions. So that SANE report is invaluable at the charging stage, and I ask all law enforcement agencies to get that for us and submit it to us, so that's something we can look at to determine whether charges or when charges are appropriate. Noticing that my slide, the gallery thing is covering up my slide, so so we certainly want that information. I will say that even at the charging stages, we are advocating for the victim as much as possible. What charge is provable? What evidence is admissible? What will the victim face in a particular prosecution in terms of issues that might come up? What is her or his comfort level with the process? We're not always able to have that full-on discussion or process when something comes in where the person was recently arrested and we're on a time clock. But as often as we can and as frequently as we can, we want to know where the victim is at with this process and where he or she, where his or her comfort level is with the fact that we are pursuing charges. And one of the ways I have told our prosecutors that to advocate is to build credibility with victims from the very beginning. Make sure that they are heard. Make sure you are charging what the evidence supports to charge. And if you can have conversations with the victims at the very beginning of this process, they are definitely encouraged to do so. Obviously, there are circumstances where we have to make the decision to decline the case. And one of the things that we do here in Dakota County that was very important to me as someone who's advocated in these cases for many, many years is that we give the victim an opportunity to chat with the prosecutor about any time that a case is declined. So we can have a discussion with them about the reasons the case is being declined, so we can answer questions. And as I put in all capital letters, so we can listen. That meeting can frequently be a listening session where we hear from the victim as to how they're feeling about the process. Sometimes we hear a tremendous amount of relief. Sometimes we hear people who are so upset that the case has not been prosecuted or isn't being prosecuted. Some people aren't really processing all that information because it's a meeting that we're giving them information about the law and about the facts and about how we think we could not go forward in these cases depending on the circumstances. And that can be a lot to absorb for victims. So we always actually offer a follow-up meeting after that to say, if there are questions that you have after this, things that come to mind because you just didn't think about it before or you didn't know to think about it before, you can have that follow-up meeting as well. And one of the cases I think about as an example of a case that was a tremendously difficult declination meeting for me as a prosecutor. It was a circumstance where I had to felt that I had to decline the case because of the surrounding circumstances. And I won't go into all of the details, but I can tell you that some of the most difficult cases that we review and prosecute involve significant amounts of alcohol consumption because of those memory impairment issues and because of the inability to have some sort of a corroboration, no video surveillance, nobody else there, nobody who can observe anything that occurred, and a lack of memory. Those cases can be tremendously difficult to prosecute, and this fell into that category. And we had a conversation about it, and it was a difficult conversation, and she was disappointed, and we spent a lot of time chatting about it. And I will say that eventually there was some additional information that came to light, a small amount of information, but additional information. And there was another prosecutor who did prosecute the case, which I think was the right thing to do. The sad part was that after the first prosecution, it was a hung jury, meaning they could not agree on a verdict, and then a mistrial was declared because it was part of the group said yes, and part of the group said no, guilty, not guilty. And so after the case mistried, then it was tried again. So at this point, you now have the victim telling her story a minimum of 3 times, if not more, because of the investigation stage of things. And then she testified a second time at the second trial, and it ended up being an acquittal. And it was a very difficult process for her to go through because she really had to tell her story on multiple occasions, and it did not end up being a good, and from her perspective, and frankly mine too, a fair result. But those are some of the things that we talk to victims about when we talk with them about declining the case. We talk with them about concerns about successful prosecution and the importance of not putting him or her through a process that is going to be very, very challenging and unlikely to provide a good resolution from our perspectives. Those are our hardest conversations, but we do have to have them as ministers of justice and as people meeting our ethical obligations. Those are conversations that we do have to have. I will say that what's most important to me as someone leading the division is that the victims do know that they are able to be heard in those communications, and that they do have a voice, and they are able to interact and talk with us and ask questions about it, not that it's in the form of a letter. So charging the case, an advocate is usually assigned from our office before charging. We try as often as possible to have pre-charging meetings with victims to assess their comfort level with the process. As I've said, the advocate regularly communicates with the victim when a case is charged about the process. They're informed of their rights to be present for the hearings, plea, the sentencing, to have any input or to be notified of any plea offer. I always ask for input for plea offers because I want to know what they think. I tell them that I have to consider, I have to make the decision ultimately as to what is the appropriate resolution, but that input from the victim is about as high on my list as anything as to what needs to be considered, and they know that. And the court and counsel are regularly advised of the victim's wishes in the case. We have discussions with the victims about motions, memos, any challenges that might come up. We want to prepare the victim for what they're going to hear in court, because things that get argued in court are offensive and upsetting to victims. She was drunk. She goes to therapy. She's a mess. She's following him. She's emailing him after this happened. All these things that victims will hear just cast off very easily by the defendant or the defense attorney can be very, very difficult for them to hear. And we try our best to prepare them for that. We do prep with the victim and get them ready to testify, get him or her ready to testify. We put the victim on the stand. We prepare them for possible outcomes. And I try and tell the victim before they testify that the only thing you could ever do wrong in a case coming to testify is to not tell the truth. That's the only thing that could go wrong. This is your story. You get up there and you tell it. And if there is a way, if there is something that can't be said, I'll let you know ahead of time. I'll let you know what the judge says about certain rulings. But I want victims to feel like they're not going to screw it up because they already feel a tremendous amount of pressure, and I don't want them to feel like like something they could do could make everything go wrong. It's tough enough. So we prepare them for all the possible outcomes. We have post-trial conversations about the results and the next steps. You know, hopefully if we get a conviction, we're preparing them for a victim impact statement when they get to come into court and say how this impacted them and how they were affected by it. I have a slide here on juvenile prosecution. This is my last slide. I wanted to put that in there. I don't focus on juvenile prosecution. Pauline Hallpenny supervises juvenile prosecution in our office, but there are some different goals with juvenile prosecution. You know, the perpetrators are under the age of 18, and frequently the victims are under the age of 18 as well. And as you can even see from just some of the language, there's a different goal. It's the idea is that our perpetrators also being children impacts how we want to treat and handle those particular cases. And the goal is more towards the protection of children as victims and the hopefully rehabilitation and assistance to children who are perpetrators to get out of any kind of a cycle of abuse. It is a petition, not a complaint in juvenile court. It is a disposition, not a sentence, and it's an adjudication, not a conviction. So even our own language relating to juvenile intervention is different. They don't have jury trials for the juvenile cases unless this person is in EJJ, extended juvenile jurisdiction. There is a pre-charging diversion program in our office for juveniles, and that relates to those non-violent sexual offenses where perhaps there was some sort of a relationship of some kind between juveniles. Someone may be able to actually be diverted out of criminal prosecution, or petitioning for them in juvenile court. So that's a very cursory overview of juvenile. The rest of it, as Pauline assured me, is yes, they get information from law enforcement and review it for whatever charges are appropriate for them to file some sort of a petition as it relates to their particular juvenile perpetrator. So different goals, but similar process to get to the court system. That is all I have. I think I'm pretty close to time. Yep, I am. So I note that there are probably a few questions. And Jenna, I don't know if you want to facilitate those or if you just want me to look at the chat. How would you like to do that?
Absolutely. So we don't have anything in the chat. I've been keeping an eye on that. So just wanted to open it up. Does anyone have any questions? You can put it in the chat or unmute yourself, whatever you're comfortable with. Okay.
All right. Well, I don't know I saw Millie is here. I don't know who else is here, but thank you all for attending. I hope that this was helpful, and my email is at the bottom slide there that's present right now. So if you have any questions, please feel free to reach out to me. I'm happy to chat with you about them. And thank you so much for attending.
Thank you.
Bye.
Well, great job, Sherry.
Well, thank you. I can't figure out how to leave, but yeah, I saw Millie on